my icon, my idol, Honorable Justice V.S. Dave, former judge of the Rajasthan High Court. सर आपको देखकर अल्लामा इकबाल का वो शेर याद आता है, हजारों साल नरगिस अपनी बेनूरी पर रोती है, बड़ी मुश्किल से होता है चमन में दीदावर पैदा. I request the audience to kindly stand up and give a standing ovation to this legendary figure. We are fortunate to have him here amongst us. My profound gratefulness to my elder sister, Justice Mehta, former judge of the Rajasthan High Court and chairperson of the Gombar Education Foundation, to have given me this opportunity to receive the blessings from Justice V.S. Dave. I'll tell you that for the very short period he used to come to Jodhpur for holding court, all of us young lawyers would line up, really praying to God that our matter should be taken up by Justice Dave. That was the kind of aura he had when he sat in the court. Every line of what he said is firmly entrenched in our minds. I'll tell you of one case. It was a case wherein an informer of Raw had been murdered in Bardmer. To my mind, I was arguing the application for suspension of sentence. To my mind, there was hardly any evidence to connect the accused with the murder. So I argued the matter. Justice Dave was fairly convinced, but then he said, Sandeep, इसने एक frontiersman का murder है, इसलिए आज इसकी जमानत नहीं लेंगे, इसको बाकी आगे कभी try करना. But that was the way he viewed the things. That was remarkable qualities and the appreciation of evidence, how to apply law to the facts of the case. You read any one of his judgments and that will be a greatly enriching experience. Once again, sir, I consider it my privilege to have shared dais with you. Shri Dinesh Agrawal, Dr. Rajendra Singh Sangwan, Shri Dinesh Agrawal, the chair trustee of the Rajasthan Education Trust, Shri Rajendra Singh Sangwan, President Raffles University Neemrana, Dr. Pranay, Dean Faculty of Law, Shri Ravi Sharma, District Judge Alwar, other judicial officers present here, Mrs. Vidushi, dignitaries present in the auditorium, the bright and young students who have participated in this moot court competition and who are the future of the legal profession in this country. It is indeed my immense pleasure and privilege to be amongst you for this valedictory ceremony of the moot court competition, which is being held in the memory of the Doyen of the Rajasthan Bar, the legendary lawyer, late Shri C.L. Agrawal. I must tell you that I have also had a privilege, being the Vice Chairman and Chairman of the Bar Council of Rajasthan, to have organized one lecture in the memory of Shri C.L. Agrawal sir. Shri Agrawal, as Justice Dave just shared, was a pioneer in legal education. He was, in addition to being a legendary lawyer, he had a great contribution to the upbringing of young members of Bar. He has left behind a legacy as one of the greatest judges this country has seen. I have had the privilege of seeing Justice Agrawal in the court, and I tell you, it was a great and an humbling experience. The way, in a soft manner, Justice Agrawal used to handle the most complicated of the cases was remarkable. So when I look back at those days, I feel perhaps Those were the enriching experiences which today help me in the onerous task of dispensation of justice. This moot court competition, which has been organized by the Raffles University, is on a subject which is both timely and intellectually stimulating. One that explores the dynamic interface between emerging technologies and the law. As Justice Benjamin Cardozo once observed, the law must adapt itself to the needs of the changing society. In an era where technological innovation is advancing at an unprecedented pace, the law is increasingly called upon to confront questions that were scarcely imaginable a few decades ago. But yet I must remind you, while you grapple with the advantages and the disadvantages of the artificial intelligence, we must never forget the real-time intelligence and experience which the legends like Justice Dave exude. AI can never be a substitute for real-time intelligence. The Raffles University, I must say, has in a relatively short span of time carved a distinct identity for itself by promoting academic excellence, innovation in learning, and a commitment to holistic education. I was taken around for a short tour of the campus and I am truly impressed. The campus, as we see, is situated amidst the serene surroundings of the Agrawal Hills. The university embodies the educational philosophy inspired by the Gurukul tradition. It fosters a learning environment where intellectual inquiry, mentorship, and character formation coexist harmoniously. Within this vibrant academic ecosystem, the School of Law has steadily evolved into a center of meaningful legal education. By encouraging rigorous scholarship, practical exposure through legal aid initiatives, and participation in advocacy exercises such as moot court competitions, the institution has been playing an important role in shaping young legal minds who will contribute to the development of our justice delivery system. By bringing together students from various law institutions across the country and by engaging them with complex legal problems, competitions such as this serve as a valuable platform for nurturing the next generation of advocates, jurists, scholars, and judges who will carry forward the ideals of justice, fairness, and constitutional governance. At this stage, I must refer to the statistics just now shared by Justice Gombar that 13 students from this institution are now gracing judiciary across the country. I must congratulate the Raffles Law University for its remarkable achievements. As I look across this distinguished gathering, I am filled with great confidence in the future of the legal profession. Before me stand young minds, sharpened by knowledge, animated by intellectual curiosity, and guided by a commitment to uphold the rule of law and the enduring ideals of justice that form the bedrock of our constitutional order. Moot court competitions, as we know them today, are the product of a long pedagogical evolution in legal education. Justice Dave just now referred to the commencement of this system under the able leadership of late Sri C.L. Agrawal Sahab by the signing of the document. They therefore thought that this craft must be refined through the disciplined simulation of courtroom practice. In our country, this tradition gained organized national recognition in the year 1981 when the Bar Council of India convened the first national level moot court competition at New Delhi. Since then, mooting has steadily expanded across universities and has become an integral component of the modern legal education. As we gather at this valedictory ceremony, we are reminded that mooting is not merely a competition. It is a formative discipline that cultivates intellectual rigor, ethical responsibility, and the habits of preparation that lie at the heart of effective advocacy and administration of justice. When we were students of law, this structured ecosystem had not yet taken roots. Opportunities of the kind the young scholars experience today were virtually non-existent. Our exposure to advocacy was largely limited to classroom lectures, and that those two were very infrequent, I must confess. Occasional debates, and of course, the invaluable visits to trial courts and the High Court, where we could observe proceedings from the gallery. Of course, we did not have the opportunity to act as participants, which you now do. This systematic simulation of courtroom advocacy and the structured argument has now assumed prominence. I must say and candidly admit that evening law classes of that era would scarcely be described as an adequate preparation for the realities of litigation. But we had an advantage. Because the classes were in the evening, we had ample time at our hands to go to the courts and watch the real courtroom battles. I, of course, had a heritage of legal legacy in my family. I started visiting courts and I would observe my late maternal grandfather, the legendary lawyer of this state, late Shri Makturmanji Singhvi, arguing the cases, cross-examining the witnesses, and showing his codecraft, which is cited even till date, that he would softly win over the hearts of the judges. Those tricks of the trade, which I learned by going to the courts while I was undergoing the 3 years law degree course, are the real experiences which have made me the man I am today. So these courtroom visits, I must stress upon you, they are invaluable as the Moot Court itself. However, the structured way in which the moot courts are organized, that underscores their significance. We, of course, in our generation, largely relied upon observation and experiential absorption to the bridge that divides between theory and practice. You are privileged. You are equipped with structured platforms that consciously integrate both. Today's moot courts replicate near authentic courtroom environments. The courtroom which I was shown today, that would put many a courtrooms even in the high courts to shame. That's fantastic, absolutely. These experiences transform legal principles into applied advocacy skills, ensure that academic learning translates seamlessly into professional readiness. In this evolution lies one of the most meaningful advancements in modern legal education. In my 4 decades within the justice delivery system, does translate seamlessly into effective legal practice. That is where you, my dear young students, stand at a great advantage. Yet, the underlying objective remains unchanged. That is to refine the essential attributes of a lawyer. Mooting sharpens the capacity for rigorous legal research. It demands fidelity to the precedent, compels clarity and precision in articulation. It trains the mind to identify the decisive authority, to structure submissions in a coherent and a persuasive manner, to anticipate counter-arguments, and to respond to judicial interrogation with composure and restraint. At this stage, I must refer to a remarkable moot court competition which was organized in the memory of late Shri M.M. Singhvi sir. The judgment of J. Jayalalitha had just been delivered by the Supreme Court. The moot problem was exactly on the same proposition. A young team of women lawyers from Chennai argued the final round, and the bench was comprised of Justice R.C. Lahoti, Justice G.S. Singhvi, both judges of the Supreme Court, and the Chief Justice of the Rajasthan High Court. Those girls were given the proposition which ran directly contrary to the view taken by the Supreme Court. And mind it, at the end of the arguments, when the time came to decide the matter, the comments of the bench were that had the matter in the Supreme Court been argued in this way, perhaps we would have reached to a different conclusion. The preparation of written memorials too is of profound significance. It instills discipline in drafting and precision in thought. It reminds us that many cases are shaped as much as by the written word as by oral advocacy. Indeed, in appellate courts especially, clarity on paper often determines the direction of hearing. I'll share my real life experience with you in this regard. My grandfather, Shri M.M. Singhvi sir, he was a doyen of the bar. He had a huge practice and large number of files. He stopped coming to the courts because of ill health. I got almost 2,000 files in which Shri Singhvi Sahib had been briefed. It was a big challenge. But I'll tell you that merely by reading the memorandums of appeals drafted by Shri Singhvi Sahib, I could argue the cases. I need not refer to the record at all. That was the quality of his drafting. That's what how drafting affects the outcome of a case. Beyond the acquisition of skill, mooting also contributes to the formation of character. It fosters teamwork, professional courtesy, and most importantly, respect for opposing counsel. These are the qualities that define a good lawyer. The manner in which an advocate conducts himself in court, particularly the humility and fairness shown to the other side, often leaves a lasting impression on the bench. And this I can say, speaking from personal experience, is an absolute truth. A lawyer who has humility and who respects the other side, and of course, who has that quality of stating the truth, he gets brownie points much more than the other lawyers. Above all, mooting nurtures ethical integrity, reminding us that in the profession of law, how one advances an argument is just as important as the argument itself. In the words of a great judge of this state, Justice Kan Singh Parihar, way of presenting arguments is just like परोसकारी. आप खाना कैसे परोसते हैं, किस प्रेम से परोसते हैं, उतना ही खाना खाने का आनंद आता है. So way you present your arguments, the judge would react and judge would absorb those arguments accordingly. It is often said that the lawyers are foot soldiers of the Constitution. It is through diligence, integrity, and commitment to justice that constitutional values find their voice in the courtroom. With these reflections in mind, let us now turn to the moot proposition that has brought all of you together and us together on this occasion. Dear friends, the moot proposition, which has been framed by the Raffles University, engages one of the most intriguing frontiers of contemporary law, the intersection of artificial intelligence, immersive digital environments, and the regulation of online gaming platforms. We stand today at a transformative moment in legal history. Technology is no longer merely a medium through which the games are played. It has evolved into complex digital ecosystems capable of shaping human behavior, structuring incentives, and influencing decision making through sophisticated algorithms and simulated realities. Modern gaming platforms increasingly operate through AI. They operate through virtual simulation and data-driven behavioral design. These systems generate missions, rewards, and interactive experiences. These experiences which blur the boundary between virtual participation and real-world consequences. In such environments, individuals may engage with algorithmically structured tasks, believing them to be a part of controlled digital simulation, while the consequences of those actions may extend far beyond the virtual world. The Moot problem placed before you precisely captures this technological dilemma where immersive gaming intersects with questions of criminal responsibility, inducement through digital incentives, and the broader accountability of the digital platforms. The issues raised in this proposition are both complex and fascinating. They invite reflection on whether traditional doctrines of criminal law, particularly those relating to intent and culpability, can be applied without modification when human conduct is influenced by technologically generated environments. They also raise the question of whether algorithmically structured rewards within the digital platforms may, in certain circumstances, amount to inducement or encouragement of unlawful conduct. Beyond individual responsibility, the problem further compels us to consider the possible extension of liability to those who design and operate such technological systems, including the corporations and the individuals who develop the underlying platforms. Another important dimension of the proposition relates to the role of the data and digital architecture in shaping user behavior. Modern gaming platforms rely extensively upon the collection, analysis, and processing of user data to generate missions, optimize engagement, and structure reward systems. When such systems operate across national borders and digital networks, the question would inevitably arise concerning privacy, regulatory oversight, and the responsibilities of the technology companies operating such systems within a global digital ecosystem. These questions, my friends, arise at a time when regulatory landscape governing online gaming itself is undergoing a significant transformation. Legislatures across the world are increasingly seeking to balance the opportunities which have been created by the digital gaming economy with legitimate concerns relating to consumer protection, financial harm, behavioral manipulation, and responsible technological development. We have seen young children who are addicted to these gaming platforms being led to commit self-harm. These are very serious consequences. Therefore, the emergence of regulatory frameworks to govern the online gaming is very important, innovation and public welfare. In addressing the proposition, you are therefore called upon not merely to interpret legal provisions, but to engage with deeper questions about how law must evolve in response to technological transformation. You are required to balance innovation with accountability, digital freedom with legal responsibility, and technological possibility with constitutional values. The learned judges who judge the moot court competition have had the opportunity to evaluate your written memorials and oral submissions. In doing so, they must have assessed not only the eloquence of your advocacy, but also the depth of your research, the clarity of your reasoning, and your ability to respond thoughtfully to sustained judicial questioning. Equally important was the professionalism, composure, and the respect with which you conducted yourself. Qualities, as I said, which are essential for every lawyer who aspires to serve as an officer of the court. As you conclude this competition, I would urge each one of you to reflect on the larger significance of the issues which have been debated. The questions raised in this moot will not remain confined to academic exercises. They will influence litigation strategies, legislative policy making, and judicial reasoning in the years to come. The responsibility will rest with your generation, this young generation of lawyers, to ensure that as technology continues to evolve, the law remains capable of safeguarding justice, accountability, and human dignity. Technological change may be inevitable, but ensuring that innovation operates within the discipline of law and constitutional principle is a responsibility that the legal profession must renew with every generation. To all the participants who are gathered here today, I would say, embrace every moment of this journey. Learn not only from your success, but equally from your setbacks. For it is often in challenge that true growth occurs. When a judge interrupts you with a probing question, receive it with quiet appreciation. It signifies engagement and prepares you for the rigors of real courtrooms. Judicial questioning is not an obstacle. It is an invitation to think more deeply and refine your reasoning. Even your opponents, in exposing the vulnerabilities of your case, render you a professional service by sharpening your analytical discipline and advocacy. The resilience, intellectual rigor, and the ethical grounding cultivated here will matter far beyond this competition. The skills you refine in this competition will one day defend rights, protect liberty, and above all, uphold the rule of law. Dear students, while one team may ultimately receive the trophy, the true accomplishment belongs to every participant who undertook this demanding journey of preparation and reflection. The confidence forged under scrutiny, the clarity developed through structured argument, and the composure sustained under pressure will endure far longer than any medal or a certificate. Moot court competitions are therefore invaluable in shaping research, discipline, and advocacy, yet they are only the threshold of the legal profession, not its culmination. Real courtroom battles demand not only intellectual skill, but humility in learning, patience in the process, and maturity in the judgment. Regard your moot experiences, therefore, as a strong foundation, but never as a substitute for sustained effort and ethical depth. The law, as it is said, is a living instrument, continually evolving with the needs of the society. As future custodians of this profession, you must be prepared not only to interpret the law as it stands, but also to shape it in accordance with justice and constitutional conscience. As I draw my remarks to a close, permit me to share a perspective from the bench. When I witness a well-prepared advocate advancing a cogent submission and respond thoughtfully and respectfully to judicial queries, I am reminded of the solemn responsibility that rests upon those entrusted with the administration of justice. Every order pronounced and every precedent laid down shapes lives and sustains public confidence in the justice delivery system. As Lord Denning famously observed, "Be you ever so high, the law is above you." It is this responsibility that gives enduring significance to discipline, intellectual rigor, and ethical grounding which you cultivate today. What may appear as an academic exercise is in truth preparation for stewardship in a system where words carry consequence and advocacy carries impact. At the end, I extend my sincere good wishes to each one of you for the journey that lies ahead. May you uphold the majesty of the law, preserve the dignity of justice, and contribute meaningfully to the continued strengthening of our legal system. I convey my warmest congratulations to all the participants and my appreciation to the organizers and the faculty whose dedication has made this enriching journey possible. Through forums such as this, you are not merely preparing students for degrees, you are shaping advocates of high competence, character, and conscience who will sustain both the profession and the justice delivery system for the last man standing. My sincere gratitude to the Raffles Law School, my elder sister, Justice Meena Gombar, for having given me this opportunity to be amongst you in this fabulous setting. Thank you. Jai Hind.